Siggy, you want some coffee? Yeah. You want some coffee?
It's been just Bill Mayo and his dog since the death of his partner of 18 years, and the Rutgers professor insists that a policy at the state university is partly to blame. The plight of gay partners. Should they share all the rights of straight married couples? Should they have the right to marry? Gay rights, gay marriage. On the docket for this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
When it comes to gay and lesbian rights, New Jersey is among the most liberal states. So why should gay professors at the state university still be claiming discrimination? What's the chance that they'll win a suit designed to give full rights to gay domestic partners? And will a ban on gay marriage become law this year under a bill now pending in Trenton? Just a few of the questions we'll be taking on this edition of Due Process. But first, here's Sandra King.
Raymond, if you thought it was all settled, that the fight for gay rights was over and won, then you missed some major events last year, like the loss of a federal law that would have barred employment bias, or the win of a measure in opposition to gay marriage. And even here in New Jersey, an anti-same-sex marriage bill is pending, and the Rutgers suit is still making news. But it's not just the stuff of hearings and briefs, as we found out when we looked beyond the courtroom.
If I had received the health benefits in '92 when we first requested it, I feel strongly that Steve would still be alive today. I don't really have much doubt about that.
Steve was Bill Mayo's longtime companion, his domestic partner for 18 years. He died of AIDS 4 years ago, and Mayo, a professor of ceramic engineering, insists that Rutgers may be to blame. There were, he claims, doctors and drugs and treatments that Steve was forced to pass up. Things that could have been covered by the state's health benefits plan if Steve had been considered a dependent or a spouse.
We exhausted our personal savings. We both took out significant loans from our parents. And ultimately, shortly after he died, I found that since there were no cash reserves, that I ultimately lost my house in addition to using all the cash that we had.
So Bill Mayo is an enthusiastic plaintiff in a suit designed to extend health benefits to the partners of other Rutgers faculty and staff, a suit that so far has failed.
The word spouse is set forth in the statute enabling the state health benefits program to function. Spouse has an ordinary meaning. You cannot defeat that by saying that spouse means something other than a legal marriage when all the cases have held that, when that is the ordinary meaning of the word.
In short, it is the state's contention that at Rutgers and throughout the state workforce, nothing but marriage can give coverage to a partner, even if, like English professor Louis Crew, you've considered your same-sex lover your spouse for nearly a quarter of a century.
Of course, I've used the word for 23 years. Spouse or husband, and he uses spouse or husband for me, surely.
But the fact is they're not identical to a spousal relationship. And there is...
Just because there was no ceremony.
That's correct.
And despite real gains in the gay rights movement, here in New Jersey and throughout this country, legal marriage for gays is simply not an option. In fact, in the wake of a ruling last year that made same-sex marriage legal in Hawaii, a ruling still on hold pending appeal, the Congress passed and the President signed a bill denying federal recognition of gay marriage. And there's similar legislation pending now in Trenton. It is a kind of catch-22 that the appellate court hearing the Rutgers case seemed to acknowledge.
Obviously, those who are heterosexual have the ability to go forward and have a ceremonial lawful marriage and qualify for the benefits if they're committed in that way. That is not available to homosexual or lesbian domestic partners. Is that not discrimination based upon sexual orientation?
No.
And in their opinion last month, 2 members of the 3-judge panel said it was unjust to deny the health benefits to long-time committed partners like those of Bill Mayo and Louis Crew. Still, the court denied their suit, insisting that change should come legislatively. But the plaintiffs and their backers have now set their sights on the state Supreme Court.
Unfortunately, the university is trying to push the blame off to the state. The state, in turn, is pushing the blame off to the legislature. The legislature says it's not our concern, it is a public interest.
They're clearly violating the law against discrimination, where they're discriminating on marital status and sexual orientation, and also equal protection under the state constitution.
And gay rights activists like Gina Reese and her domestic partner Wendy Berger say the irony is that in most other respects, New Jersey leads the country in its liberal gay rights laws.
New Jersey should be ashamed of itself. We are on the cutting edge and leading the fight for full equality in the nation. No other state has the laws that we have in New Jersey. And to be behind on the issue of domestic partnership is insane.
Neither Gina nor Wendy works for the state, but they see the Rutgers fight as their own, and they hope that if they win there, gay marriage might be next.
This is going to be interesting, too. They're going to do like a sister-sister Cuba delegation.
They already wear rings to mark their commitment, and like most long-time domestic partners, they have those protections that can be gained by contract, but those, they say, go just so far.
You can have them, but they're often overturned and challenged, so that it doesn't have the stature that a marriage license has. Things like taxes and inheritance and the ability to have who you want be your next of kin and to have those kinds of things are still issues that we're fighting for.
Still, New Jersey may not be ready for gay marriage, though there is a state law against discrimination, and in 1992, it was amended to cover bias against homosexuals. The Rutgers plaintiffs say that's reason enough why the state Supreme Court should hear their case and rule for them. And Rutgers already gives recognition to same-sex domestic partners, but not when it comes to benefits or insurance. The state says that would be simply unmanageable. Rutgers officials refuse all comment. But nationally, those benefits are being granted by hundreds of corporations and dozens of colleges, among them, Raymond, Rider College and Princeton University, both right here in New Jersey.
Still, Sandy, they remain the exception, and the fight over full rights for gay partners continues to rage, as we'll see in just a minute when activists on both sides of the gay rights question meet here and debate. You stay with us.
Well, as I have said repeatedly, I'm not comfortable with the idea of gay marriage, but I do think it is important that we start to explore what I believe is at the root of the issue here, which is the ability of an adult to designate their beneficiary, whether it be a heterosexual partner or a homosexual partner.
For benefits?
For benefits, yes.
And why aren't you comfortable with the idea of gay marriage?
It's just not something that I think is important in recognizing the relationship. It's not the intention of marriage as it is sanctified in the church, and I'm just not there yet.
And it seems that much of America agrees. It's one of those subjects that draws deep emotional reaction on both sides. It's a battle that continues to rage, as evidenced by our guests. Robin Wernick is an attorney whose specialty is gay rights. John Tomeke calls himself a pro-family advocate who's been lobbying the New Jersey legislature for a bill that would ban recognition of gay marriage. Welcome to both of you. Mr. Tomeke, let me start with you, because the report we just looked at in some ways involves litigation that could be resolved by simply allowing anyone who wishes to marry anybody they want to. That is, allow gay marriage. I take it you would oppose that.
Oh, absolutely.
Why?
But before I answer why, it's not really like banning same-sex marriage. What the bill does, it sets the public policy clearly about the state of New Jersey and saying that we recognize that the definition of marriage in our society is one man and one woman.
But the question is, why do you care to have that definition that would exclude people who wish to marry someone of the same sex?
Well, who wish to. First of all, laws must reflect some principles. This is not an issue of an extension of rights. It's an issue of attacking a fundamental principle that's been in our society. If I look over 7,000 years of history, then it would just be me talking, but I'd rather quote a sociologist from Harvard, who's obviously not a conservative right-wing institution, in a book written, I think it's 1956, Pitirim Sorokin, who stated that when he looked over 7,000 years of history, he said that if you remove the premier protected status of marriage to that high plane that we keep it to, with one man and one woman, it is the precursor of the demise of that civilization. So we argue on the side of history, we argue on the side of civilization, that if you want to keep the society that we have so it doesn't destroy itself, do not take away that protected status of one man and one woman to be a marriage.
Ms. Wernick, it seems we're starting at a more fundamental place than I thought, but I think Mr. Tamaki is arguing that if we extend the concept of marriage to include same-sex marriages, that civilization would collapse. What do you think about that argument?
I think it's absolutely ridiculous, respectfully. Traditions change. If we look at it, in the beginning of our country, we had something abhorrent. We had slavery for black people. And that's something we certainly have changed in our society. And this is a tradition that's changing as a result of societal changes. I think it's very important that all people have the right to marry if they choose to. Right to marriage carries with it a lot of benefits, as you know. The right to inherit by intestacy, which is if you don't have a will, you would inherit from your spouse. Right now, gays and lesbians don't have that right. If they don't have a will, they wind up getting cut out of each other's estates, whether they're together 25 years or 10 minutes.
So you make a will?
Yes, you can make a will, but sometimes you can't do that, or you're not able to do it. You may be incompetent.
Let me ask this question. It's interesting that on the one level, your argument is in terms of some of the specific policy interests that would be served. Your argument, Mr. Tamaki, is in terms of a broader philosophical position that seems one that's not flexible. I mean, if you really believe society would collapse, you're not in a position to bargain or to do what the normal legislative process does.
Well, all legislature must reflect some principles, some moral standards. So those of us who like to say history is a good teacher. Why should your moral standards prevail in this issue? It's not my moral standards. Well, it's not my moral standards. It's the standards on which this country was founded. They are Judeo-Christian principles. Okay. Washington told us in his farewell address, religion and morality are indispensable supports to good government.
Is there anything in the Constitution, Ms. Wernick, that you know of, or in the basic founding documents that addresses the issue of heterosexuality versus homosexuality?
Absolutely not. And he's saying this is what Washington brought forth. Well, they also brought forth the concept of slavery, and that went out a long time ago.
It was not perfect.
So this argument of tradition must stand does not make any sense. We must change as we become educated.
Mr. Tamaki, let me ask you this. How do you respond to Ms. Wernick's argument that as time changes, some adjustments have to be made in terms of things that have a concrete effect on the way people are able to live decent, full lives?
Well, you just said concrete effect. Yeah. Okay. Now, first of all, let's understand that we're talking about a population which, according to Dr. Kinsey, he said is 10%. Those figures have been severely criticized. It's somewhere between 2 to 4% of the population. We're not talking about issues involving discrimination in housing. There should be no discrimination in housing. There should be no discrimination in health care. That would be good public policy. It is also good moral principles. What we're saying is, as we look over sociology, history, anthropology, you have Dr. J.D. Unwin of England, who came out with his 80 society study going over thousands of years of history, and he likewise said, if you allow a society to go to a licentious sexual pattern, if you move away from that protected status of one man to one woman, then it's the precursor, it's a sign of the demise of the civilization.
Ms. Wernick, you wanted to
let me just hook back in if I could. Now, what she is saying is that things are changing. Principles do not change. Rights and how we look at rights may change.
Well, let's say that's true. What he's talking about really is a church and state issue, and we know we have a separation of church and state in our Constitution. So if that's the case, then perhaps we can have, if you're trying to make everyone happy, which I'm not necessarily trying to do, but churches can make up their own decisions. We're not saying churches have to approve of gay marriages, but certainly the state must. And in New Jersey in particular, with the law against discrimination, I think they're going to have to. I really do.
Why do you think they'll have to?
Because the law against discrimination is leading towards that. It says the state cannot discriminate education, employment, and a whole litany of things. For example, the Rutgers case.
Were you in favor of the extension of the law against discrimination to include homosexuals? Did you favor it at the time?
Well, For the reasons it's now being used as a challenge, all right, the answer would be no. Should there be no discrimination in housing?
Do you now favor the principles that are clearly in the statute, that is no discrimination in housing, in benefits?
Okay, but it's being extended because
As
now
it
they're trying
before
to
we
say,
get to the extension, do you favor it as it now stands? We'll talk about the future implications.
I have difficulty when we say we're going to treat people because of sexual orientation, which we believe has no genetic situation, or when we discuss the issue or raise the issue before of race, that's something that you're inherently born with. There's no scientific study out here that says that homosexuality or a gay lifestyle or lesbian lifestyle is something that you're predestined or preordained to be able to do it. Wait a minute. It's something because you raised the race issue. The race issue is something is somebody born with, and there's nothing, they have no control over that.
The Hawaii court that dealt with this issue kind of avoided the question of whether you were born with it or not by saying people should not be discriminated against on the basis of the gender of the spouse they take.
Even if people are born with it, or they decide to change it, or they decide to be gay, even if they're not necessarily born with it, that's their right, and they shouldn't be discriminated against because of what their orientation, wherever it may come from, whether you're born with it or you choose that lifestyle. Discrimination should not exist in our country. It's something we've fought strongly not to have, and I think this raises a big issue of discrimination.
While we're on Hawaii, let me just stay there for a minute. The Hawaii Supreme Court is on the verge of affirming an earlier decision which seems to be one that will permit gay marriages in Hawaii.
Based on the Equal Rights Amendment of the state constitution of the state of Hawaii.
Constitution of Hawaii. But the ERA. But the implications, actually it's the equal protection provisions of the Hawaii Constitution, but what will happen is that people may get married in Hawaii and say that those marriages should be recognized as all others in other states. The Constitution requires that other states give full faith and credit to doctrines and decrees from other states, including, and marriage has traditionally been one of those. The Congress and perhaps even the state legislature of New Jersey seem to think that they can override the constitutional protection and say, we don't have to recognize
marriage.
That's
why you're very successful in court, because you've obfuscated and slid over some
Did I say something was wrong?
Absolutely. First of all, full faith and credit. The DOMA bill, the Defense of Marriage Act, passed on the federal level, in effect is saying in the United States Code, IRS, and other policies, the word spouse is going to mean a marriage, one man and one woman. So it set the federal policy and allowed each state to go ahead and do as they choose or so fit. Full faith and credit does have some limiting factors on it. For instance, we would not recognize polygamy in the state of New Jersey, recognize polygamy marriages that would come out of the state of Utah, nor would we be required, because it would go against our public policy, to recognize the marriage of a 12-year-old that might come out from another state in a southern or western jurisdiction. So there are limitations under full faith and credit.
But let me ask Ms. Warnick, do you believe that if the Hawaii Supreme Court continues on its present course and says, we'll recognize gay marriages, and a gay couple gets married in Hawaii and comes to New Jersey, that marriage, if the current legislation passes, is going to be recognized in all of its particulars, as would a marriage between a heterosexual couple, or will there be a difference?
Well, certainly under the full faith and credit part of the Constitution, it should. However, it's going to be a challenge, obviously, in court as to whether or not it will be. And it really should be, but we're not going to know until that happens.
All right, now, why would you not, in simple terms, that people who haven't read all the cases you have, why would you, I know, but you've read a lot and probably more than many of our viewers have, why would you not wish the gay couple that comes from Hawaii on the same day as the heterosexual couple to have all the same opportunities based on that marriage as the heterosexual couple?
Because you're redefining marriage. You're trying to set a new moral principle for this country.
Let me just stop you for 1 second, because you've said this a couple times, and I think it's an important part of your point. If, in fact, I'm a heterosexual couple, or you're part of a heterosexual couple living in New Jersey, how are you adversely affected? How are you harmed by a gay couple from Hawaii moving to New Jersey and saying, we want all the appurtenances of marriage?
Okay. Because we said in the beginning, we do not allow people of a certain age, below a certain age, to get married. We don't allow people to have more than one spouse right now under existing law. Your argument would get us to a point that we will have to recognize multi-union marriages.
Why?
3, 4, 5, 6,
if we
7
said
people.
2 people?
Because there is a uniqueness in a mother and a father and a family. We look over 7,000 years of history. I'm going to keep pounding that point. It's not me talking.
What's the uniqueness that you point to?
It's the protected status of what was meant by the nuclear family, what comes out of natural law philosophy, that it's a mother and a father.
How about a heterosexual couple that has no children? Why is that unique in a way that a gay couple wouldn't be unique?
I'd like to make a comment on adoptions, too. There's recently a case that came down in New Jersey from the appellate division that permitted one woman to adopt her partner's children, and they were two twins. And these people were together, these two women, for about 12 years. The woman that gave birth did so by artificial insemination, and they agreed that they would be the parents. And the appellate division said, we're going to recognize that and permit the adoption, and we can read that under the statute. So these are things, certainly, that have gone for family, as quote-unquote
New Jersey
family.
has been
These are families.
fairly open in our courts in permitting gay people to adopt children. Is that not true?
That's correct.
If that's true, why would you find them to be any differently situated than a heterosexual couple that adopt?
You're going to ask me, you should ask me, do I favor adoption by a homosexual, gay, or lesbian couple? The answer is no.
Okay, but I want to go back to your earlier point. You were saying that your position is based on what you perceive to be a uniqueness about the heterosexual couple. If they're a childless couple, or if they adopt as a gay couple might in this state, what is the difference that warrants putting up this wall that gives a lesser status, or perhaps not even a protected status at all, to a gay couple?
Because our belief is, based on anthropology and sociology, that is not a normal household. And there goes that great word, normal. What is normal? And so we're saying this is not a lifestyle.
You did put it in quotes.
Of course I have to.
Okay.
There is normal living. We have the Andrew Sullivan book. We have a lot of material that seems to be out here. And when you look at the scientific studies and some of the other medical studies that are out now concerning homosexual gay couples, they talk not about really being that faithful or that monogamous. And so when you don't have a good monogamous relationship, you do not have a stable household.
So if a study was done next month that demonstrated with reasonably sound scientific method that monogamy has about the same statistical evidence
it doesn't.
Well, but all I'm saying is, does your position change? Is your position based on a perception that homosexual couples are less monogamous? Is that the basis of your argument?
They are, based on scientific studies.
But is that the basis of your opposition to it?
It's one of them. When you build a foundation on it, you have four major points. I will always come back to an issue of moral principles, moral certainty, It's a moral issue to me.
He's basing them on, but I can tell you that I also practice a lot of family law, and a lot of heterosexual people are not faithful. That has nothing to do with it in terms of homosexuals versus heterosexual. I think we have unfaithfulness in all areas. In fact, our divorce rate is over 50% or around 50%. But I do want to address one point. John was talking about how our foundation will fall apart if we allow gay marriages or people other than a male and a female to marry. Other countries have permitted it. I don't recall, and I really don't want to state the wrong country, I think it's Denmark, has permitted gay unions of some sort or gay marriages, I don't know exactly, but that country hasn't fallen apart, and I think that argument really does not make any sense. Other countries have tried it.
Let me come back to the report with which we started this show, because here you have a series of professors who have lived monogamous lives, in one case for 18 years, another for 23 years, and say there are specific health care and other benefits they've been deprived of because the state has chosen to use the word spouse in the statute and to describe that to this point as a heterosexual couple. Why isn't that a very specific detriment to society, that people who've lived long-term, stable, monogamous relationships should be deprived of health care benefits on the basis of a preference of some, even the majority, for heterosexual over homosexual couples?
There are things that couples, homosexual, gays, lesbian couples can do. They can go into medical savings accounts. They can draw a will right now. They can go into joint tenancy by the entirety tenancy. They can do all of those things. Now, I will give you the answer the Washington Post did. When it had an application before it by people to make spousal benefits to their significant others, the Washington Post said, no, we don't think that's going to be good for the policy of the paper. We don't think it's going to be good for the economics of this paper. We don't think it's going to be good for us, period. They made a business decision. They made an economic decision. So that when you are beginning to extend families and saying it can be this wonderful monogamous gay couple or this wonderful monogamous 12-year lesbian couple, okay, we're saying society does not see it that way. We don't see it that. The scientific studies say this is not going to be a stable relationship.
Let me bring you back then to the Rutgers example we talked about. What is the consequence to society of a man like Professor Crew, who teaches for 23 years, being deprived of benefits that a heterosexual person in his same position would have?
Well, first of all, I'd like to address John's concept of gay relationships are not monogamous. The Rutgers case deals with, I believe, 4 couples, 4 or 5, I don't recall off the top of my head.
Five.
But the minimum, I believe, the relationship, the minimum amount of years that one of those 5 couples were together were like 15 years. If that's not monogamy and a serious relationship, I don't know what is. But in terms of the question of what kind of impact it will have on society, certainly it will have the impact of permitting gays and lesbians to have the same rights as heterosexuals have or as any other people have in terms of medical benefits. It's very important. You could see from the case itself that there are individuals, in other cases too, who have become economically bankrupt because their spouse could not be on their medical benefits when they were seriously ill. Now, heterosexuals don't have that problem. So what it looks at is a discrimination aspect.
John Tamaki, we're closing now, but let me ask you this. Would you have objected to Professor Carew, for example, teaching for 23 years, given the fact that he was a homosexual at a university where there were students? Would you have a problem with that?
If he's not making his lifestyle a matter of what he's teaching and promoting, and he's in teaching history or teaching anthropology, that's fine. You know,
I mean, he can't teach. You wouldn't want him to teach anthropology?
I said, you know, if he wants to, that's what he teaches, that's fine, you know. But if he's now coming in and saying and advocating this as the alternative acceptive lifestyle and making that as part of his teaching for him, yes, then I would have difficulty. But if he's just up there teaching math, you know, math is math.
This sounds like a conversation we could continue for some time. I wish we had more time. I want to thank you both for being with us, and I'm sure we'll revisit this subject in the future. That's it for this edition of Due Process. We'll be back next week with an issue that affects us all, crime. Is it really down? Then why don't we all feel safer? That's next time on Due Process. Till then, I'm Raymond Brown.
We have the same kind of stigma, and there's the same kind of confusion, and I think that what's happening, though, and what's starting to shift things is as we start to come out, because we're protected because of the law against discrimination, people start to know us. Like, our neighbors know who we are. They know that we're a lesbian couple. We don't have any problems. You know, we're like every other neighbor on the block. They knock on the door and borrow sugar, and, you know, it's like... it's like we're part of the neighborhood, and that's just how it is, and there isn't any issue about it. And I think that as we start to integrate this, and as people start to understand who we are, that'll start to shift things.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.